tuned in to the Andrew Lawton Show.
2,000 pages, ultimately a finding that the federal government was justified in invoking the Emergencies Act. That's what came away on Friday from the Public Order Emergency Commission and Commissioner Paul Rouleau. Not a slam dunk, not a complete vindication, but on the core idea of whether the Emergencies Act was justified, the commissioner sided with Trudeau, and really on the core ideas of how the Emergencies Act was used, the commissioner sided with Trudeau. And there were a couple of little criticisms he made that I think were significant, but generally speaking, he supported the bank account freezes, he supported the conscription of tow truck drivers, and he supported the overall use of the act itself, albeit with the caveat that, in his words, another reasonable person could reach a different conclusion. So there are two big takeaways here. Number one is that this is not the end of the road as far as Emergencies Act accountability goes. There are still federal court challenges, and as we talked about on Friday, there's still the political dimension of this. Voters have not yet in any formal way had their say on this chapter of Canada's political history. And then there's also what the report really said, and going through with a fine-tooth comb, now that we've had a little bit more time to do so, and start extracting what was actually said here, what was actually found, and whether it stands up to scrutiny. And for this, we have one of the best legal minds in the country, certainly when it comes to matters of liberty, Christine Van Geyn, the litigation director for the Canadian Constitution Foundation. Christine, I don't even want to ask how your long weekend was, because I assume it was in large part consumed by a bulk of this 2,000-page report.
Yeah, it's 2,000 pages when you include the appendices, so it's not all, you don't have to read every single one of those pages, but yes, I've spent a lot of time going over this. It doesn't get better. But, this, as you said, is not the final word. This is not the end of the fight over the Emergencies Act, because we do have a federal court judicial review that we brought separately, independently. This report by Commissioner Rouleau was brought by, it was called and convened by the government, funded by the government, and this judicial review is completely independent and will hopefully reach a different conclusion. So we have a hearing scheduled for that in April.
So just on the scope of that judicial review, let me ask for people that aren't as familiar with the case, are you challenging the invocation of the act, the emergency orders and emergency measures that flowed from the act, or both in that challenge?
It's both. So it's sort of two things, really. It's that the Emergencies Act was invoked illegally, that the statutory threshold to invoke it was not met. And we can talk about what that statutory threshold means. I have a very different interpretation of that threshold than Commissioner Rouleau does, and that my interpretation is more in line with what most legal scholars across the country view as the correct interpretation. And the other thing that we're challenging is the regulations that were enacted under the Emergencies Act. Those would be the measures that froze bank accounts and that created prohibited public assemblies. And we are arguing that those are unconstitutional. So sort of two approaches, two things that we're really arguing.
So when we talk about the statutory threshold, this was obviously a key part of Commissioner Rouleau's report as well. And do I understand from that this is not a constitutional challenge? It's not about the moral value of the Emergencies Act. It's about whether they satisfied that test that is spelled out in the Emergencies Act and, by extension, the CSIS Act themselves?
Yeah, so that's closer to what you would say is the way statutory interpretation operates. So it would be an illegal use of the act. That is what we are arguing, that if you use this legislation when the threshold is not met, the use is illegal, and that therefore the regulations under it are unconstitutional. But the threshold was important to know for a public order emergency. There's like the legislation has all these different parts, and they all kind of are interconnected. That's how legislation usually works. But the important thing for your listeners to know is that for the legislation to be invoked, there needs to be a threat to the security of Canada. And that is a defined term in the legislation. It's defined through reference to another piece of legislation called the CSIS Act. And what's fascinating and a huge problem is that CSIS found that under their legislation, there was no threat to the security of person. There was no threat to the security of Canada. And if CSIS found that under their legislation there was no threat and there was no separate threat assessment done, how could Cabinet reach a different conclusion? It's not reasonable, in our view, for them to reach a different conclusion. The thresholds are the same, the definition is the same. It's completely a strange interpretation, sort of this Hail Mary, let's see if we can make this argument, this novel legal argument, and get it to stick. And somehow they convinced Commissioner Rouleau of this strange interpretation.
And I know that we've spent a lot of time on the show talking about this, but I think it is important. And ultimately, it became increasingly clear near the end of those hearings back in October, November, that this was going to come down to a debate about the technicalities of the statutes and not about the fact scenario, not about, whether there was this previously unrevealed threat that was very explicit. It came down to what Cabinet believed and what these thresholds were. And when you look at the CSIS Act, which I've had the misfortune of doing a number of times now as I've covered this, it doesn't make any distinction between the different applications of it. When it's used by CSIS, there's this threshold, and when it's used elsewhere, there's a different threshold. And the Emergencies Act similarly does not put a caveat there. It says, this is the definition. It's spelled out right there. So what was the argument that the commissioner found compelling for why CSIS could find there was no threat to the security of Canada, but the Cabinet could?
It was this notion that different decision makers may rely on different inputs. But in our view, the words of the statute mean what they say they mean. And for Cabinet to reach a different conclusion when, in fact, Cabinet was lacking a significant amount of information. They did not have a separate threat assessment from CSIS. CSIS had concluded there was no national security threat. Cabinet had not even been briefed on this novel legal threshold. Cabinet had not been fully briefed by Brenda Lucki about the existence of additional other laws that could have been relied on to resolve this situation, that the Emergencies Act was not absolutely necessary, which, by the way, is another part of the statutory threshold. So Cabinet reached this different conclusion, even though they were further removed from the situation and had less information than CSIS did. So in our view, it is not reasonable for Cabinet to have reached a different conclusion. Even if they could rely on different inputs, they actually had worse information than CSIS did.
And I should also point out that even if that threat to the security of Canada is found, there are still additional layers for the Emergencies Act to be justified. That threat has to be creating a national emergency, which has its own definition, and it also has to be outside of what existing authorities available under law are capable of dealing with this. Now, I know your colleague Joanna Barron had a great piece in The Hub that really spells out some of these legal articulations here from the Commissioner's report, but the one thing that I found particularly not compelling from Commissioner Rouleau's findings is that he really conflates what police failed to do or didn't do and what bureaucratic infighting and, this sort of territorial control between different agencies did, and what the Act itself says, which is cannot effectively be dealt with under any other law of Canada. So there seemed to be this conflation of can't do and aren't doing.
Yeah, I mean, that word effectively is carrying a lot of weight in this report because what essentially, one of my friends, Aaron Woodrick from the Macdonald-Laurier Institute, has written in the National Post is using this interpretation that, police not doing a good job, disorganization, lack of communication, that is just kind of typical of government. That's a policing and governmental failure. And incompetence is not the legal threshold for using one of the most powerful laws in Canada, a law that allows Cabinet to create new criminal law by executive order. You can't just hand Cabinet that power because the police were incompetent. And look, there were a lot of policing failures. No one is disputing that. We saw that. We saw it in the commission. We actually saw it throughout the protests that the police were not doing a great job. I'm not a police officer, so I mean, I know it's a very difficult job, but there's a lot of consensus that the police failed here, but that is not the threshold. What they needed was more help from other police, not this extraordinary sledgehammer that is the Emergencies Act, that in fact, they didn't even really rely on the tools in the Emergencies Act to resolve the protests. They relied on the criminal code. So no one asked for this. It wasn't necessary. Things were ultimately resolved using existing law, and the threshold of national threat to the security of Canada, that threshold was not met. So I have a lot of problems with this report, but mercifully, we do get another chance in federal court.
And just as a peripheral note on that, to my knowledge, there were never any charges laid under the emergency orders, were there?
Well, under the emergencies orders, certainly there were accounts frozen. What do you mean by charges?
No one was criminally charged specifically using any tool that wasn't already in the criminal code, I guess is the question.
Well, I don't believe so. I believe that the charges were for things like mischief and maybe resisting arrests. But certainly the power to freeze bank accounts was used.
Yeah. Well, and that, I mean, as we've talked about in the past, didn't need charges and any other proof or recourse or anything like that. Yeah.
And the tow trucks ultimately could have been used. There was a lot made about the availability of tow trucks, and that all could have been done using existing powers as well.
The word that Joanna Barron used in her piece in the Hub that I think is a sadly accurate word is deferential. And we've seen throughout a lot of the COVID-related cases that have gone before courts, a lot of deference to government, a lot of use of Section 1 of the Charter to say that the cessation of rights, in Section 2, for example, are subject to these reasonable limits or so-called reasonable limits. And in the case of the Emergencies Act, is there a legal ability for the government to use this report as a substantive part of its argument, or does it kind of exist in a box on its own and can't be brought into a JR as justification?
No, so this is not a finding of liability. This has no legal weight. I mean, it certainly has political weight, but I would encourage the Prime Minister, if he popped any champagne, to put the cork back in, because we're coming in federal court. And we are using a lot of the evidence that came up in the inquiry. So that's one way that the inquiry is relevant to the federal judicial review. There's a lot of evidence is being incorporated into the JR.
But the government can't just table this report and say, listen, it was very reasonable. They've already found it out here.
No, and they can't bring new evidence at this point anyway.
So explain to me where you think the strongest argument is in critiquing the Emergencies Act. Do you think it is on that idea that the threshold wasn't met, there was no emergency, and we don't even need to get into the orders because the orders were illegal on that basis alone?
Yeah, so I think that one of the big focuses that we have in our material, we actually do spend a lot of time on the orders. Because the orders are a big problem, right? The notion that the government can seize your bank accounts because you are involved in a protest that they disagree with politically, that's a huge problem. And anyone who supports that type of conduct, I think you need to ask yourself how you would feel about it if it happened to a protest that you support from a prime minister who you don't support. Because that's really what's at stake here. This is a huge tool that gives the government a tremendous power to use against protests that they disagree with in the future. But yes, I think that the big thing that we're going to be arguing in federal court relates to the threshold and whether the threshold was met, whether existing legal tools would have been sufficient to resolve the protest. We think that they would have been. And the question of what the legal threshold is, which is threat to the security of Canada, as defined in the CSIS Act, not as defined in the subjective opinion of this Prime Minister, and then examining the constitutionality of the measures enacted under those under the declaration of emergency once that's been found to have been illegally invoked.
And what's the timeline for that case? What's the next key date or key step or date in that?
So we filed our factum last week. The government, I think, is trying to bring some new evidence from the inquiry, but we are resisting that. And there's a hearing scheduled for the first week of April. So I'm going to be in Ottawa. Looking forward to heading back after those weeks I spent there in November. I miss it already. So I'm going to be back, and I'll be live streaming following the hearing to explain what happened every day. So if you guys go on YouTube and subscribe to the Canadian Constitution Foundation's YouTube channel, you can watch my daily summaries of the hearing that will take place over 3 days in Ottawa.
I dare you to say under oath that you miss Ottawa. I don't think anyone could ever do such a thing.
Well,
Is there
I'm not going to be doing that. But
yeah, exactly. Is there a trial date set or a time you're anticipating it being?
Yeah, so it's the hearing date is April. Let me check my calendar. April 3rd, 4th, and 5th. Now that is subject to change. These things can change, but that's currently when I'm planning on being in Ottawa.
All right. Well, we'll look forward to that. Christine Van Geyn from the Canadian Constitution Foundation. Always a pleasure, and keep up the great work.
It was great chatting with you, Andrew.
Thanks for listening to The Andrew Lawton Show. Support the program by donating to True North at www.tnc.news.